Good afternoon, Mr. and Mrs. Miller. Today, we would like to talk about estate planning documents, and we're kind of going to give you a brief overview of what all that entails and then what is adequate for your situation. And then after this, you can visit with your attorney and then figure out what documents you want in your will. Because you do not have a will, I know you mentioned that before, we recommend that you visit with your attorney and draft a will as soon as you can, just because this is kind of a time-sensitive issue at this point. And if you do not have a will, then all your assets will be distributed to places and people that you don't want them to be distributed to. So it is very imperative that you draft a will with your attorney, and then make sure you're specific as you can, and then your assets will be distributed to whoever you want to, such as your siblings. I know you mentioned that before, or your charitable organization. I know you said that you like to donate. So just to tell you, we recommend that you have a will. So with that being said, a valid will is a legal document that provides instructions for the distribution of your property once you pass away. If you don't have a will, then your property and assets are subject to state intestacy laws, which we want to avoid at all costs. This valid will determine who gets what assets or what property, when it should be transferred, what amount, in case of like land or something, how it should be maintained or protected, or who even handles the care of this property. So it's very imperative that you list everything that you can or you can think of, and then let your CPA or attorney know. So common types of wills include statutory wills, holographic wills, and non-cupative wills. A statutory will is kind of like the most simple standard one, and it comes like at a low cost when it comes to estate planning. I know it's kind of like just like a brief overview, and it's kind of a standard one-size-fits-all and provides a standard text that really can't be altered. And then a holographic will is entirely handwritten, and it requires witnesses to testify in probate court that the will was written by the decedent in order for the court to accept it. We believe this isn't very adequate for your situation, but this is another thing you can consider. I mean, it's whatever you want. And then another one is a non-cupative will, and this is an oral will that has very limited powers. However, in Texas, these type of wills cannot transfer real estate or bank accounts, so that's another thing that you should consider when deciding what type of will you want. This only transfers ownership of personal property and cash, or the ownership rights of personal property and cash, and then everything else is left to be distributed intestate. So that's another thing that you really need to think about. So the most recommended will that we come across is the one that is drafted by a qualified attorney, which we're recommending. This attorney will kind of tailor your will to fit your needs and wishes, and it kind of reduces the probability of going through probate, which is another long process that you do not want to encounter. And it is likely to stand up in court, legalese, and it also can be very complex or simply written. It's whatever you want to do, or whatever your attorney recommends you doing as well. Also, within a will, there's also clauses. So clauses are provisions that make up the primary components of a will and instruct specific actions on defined subjects within the will. So I know there's there's a wide variety of types of clauses, and I'm gonna mention some that are very appropriate for your will. I'm not recommending that you have all of them, but these are some of the few that are very appropriate. So the first one that we're gonna go over is extordium clause, and this introduces the testator with basic information and invalidates all previous wills while naming it as the only will for the testator. So that's another thing to keep in mind. I know this clause is very important. Another important clause that should be in your will is payment of debt and taxes clauses. This will instruct the payment of your estate debts and the taxes due if you were to pass away. And then another important clause is powers clause, which is it kind of details and describes the powers the personal representative receives in when administering the estate. And then another one is the common disaster clause, which specifies which spouse is presumed the survivor to the other in case they both pass away at the same time. So this is very important as well. And then the last but not least is the testimonium and attestation clause, which establishes a testator and agrees to the will and provides additional requirements such as a witness signature. So I think this is a very important clause when it comes to including in your will. I think you should include this. Another document that I want to talk about is a living will and then the powers of attorney. These are very essential to estate planning. A living will is also known as a medical directive. So it is a legal document that details your wishes for medical treatment and end-of-life care in situations if you were to be incapacitated. This medical care treatment may artificially prolong your condition if you were to be in a state of, like, as you could say, maybe a coma or something like that. This can be very difficult to discuss. However, this is between you and your spouse and your family, what you would decide you want to do. I know this is a very tough thing to think about, but a living will basically outline your specific end-of-life wishes, which can be either drafted by your attorney for a fee, and then these wishes will ultimately be executed by the physician in charge of your care. If you do not have a living will, then it could be a long process in court, and then your family members would have a hard time trying to make a decision for you if you were to be incapacitated. And then one more other, document you could have in your will is the power of attorney. So the power of attorney is a legal agreement that provides the attorney, in fact, which is the person that is granted the ability to act on your behalf, which I think this would be a very important document to have in your will. This power of attorney can be limited or it can be extended for indefinitely. It's up to you what you want to do. And then there's two types of powers of attorney, which is the general, which gives you just unlimited power or control of the attorney, in fact, over the financial matters of the principal. And then there's also durable, which means the powers granted are continued even when the principal becomes incapacitated. And this is active immediately or only when the principal becomes incapacitated. So that's another thing to think of. And then the medical power of attorney is kind of the medical version of the durable power of attorney for health and medical reasons or decisions such as specific medications if you couldn't decide because you were incapacitated. So because you don't have a living will at this point, we recommend that you have one and then appoint anyone with the power of attorney. We do, however, recommend that you discuss this with your attorney. And then we'll also recommend what is the best option for this agreement and then your wishes and the type of situation as well.